a felon. 52924, unlawful possession of a firearm by a felon. 112324, unlawful possession of a firearm by a felon and a terroristic threat of a family or household member. You now, with us, are facing up to a year in jail and or a $4,000 fine. Good morning.
How you doing, sir?
How's jail?
Sucks, man.
Great. That's great. Because I got you. I need you to understand that.
Right away, the tone is set. This isn't small talk. This is the judge establishing dominance. In courtroom psychology, this is called control framing. Before facts, before law, the judge makes it clear. This courtroom runs on compliance, not excuses. And when a judge starts like this, you already know bond is about to get expensive. Listen.
We mean business here. We don't play. And your lawyer I'm bringing you out because it's your case. You need to understand what's going on, number one. Number two, your lawyer has asked for me to reduce your bond. Your bond now is set at $10,000. I have no idea what happened on your case. The only thing I do know is that September of 23, unlawful possession of a firearm by a felon. December 1st, 23, unlawful possession of a firearm by a felon. 52924, unlawful possession of a firearm by a felon. 112324, unlawful possession of a firearm by a felon and a terroristic threat of a family or household member. You now, with us, are facing up to a year in jail and or a $4,000 fine.
Carefully here. This charge changes everything. A terroristic threat involving family or household triggers enhanced scrutiny, protective orders, and stricter bond conditions. It's not just about what was said. It's about who it was said to and whether fear was created. And in Texas, fear is the key that unlocks jail time.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched in response to a family disturbance in Harris County, Texas.
Shh.
The complainant told the officers that her and the defendant, her ex-boyfriend, were having issues regarding child custody, and the defendant was attempting to drop the child off with the complainant, and the complainant refused to take custody because of a previous mutual custody agreement. The complainant told the officers that the defendant then stated, "I just bust your car window, and if you pull up doing anything, I'm gonna shoot your ass in the face." The complainant stated that she was in fear for her life, and the officers detained the defendant and found him to be in possession of a handgun.
All right.
Probable cause is a low bar, but it's a powerful one. It doesn't mean guilt. It means the judge believes there's just enough to move forward. And once that happens, the leverage shifts entirely to the court. Protective orders, GPS monitoring, and zero bond threats are now on the table.
Mr. Jack, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to have any contact with the complaining witness in this case. A protective order has been issued in this case. What that means is that if you violate this protective order, the state can and will file additional charges against you, violation of a protective order. And I'm going to tell you now, you pick up one of those cases and you violate conditions, I can have a hearing to hold you at no bond, zero bond. And I will do it in a heartbeat to protect my county and everyone in it. Do you understand?
Yes, sir.
I find that you are a complete danger to public safety and you refuse to abide by bond conditions. So I don't think that your bond is sufficient. I think that the 10,000 is too low because you are a danger to my public. I'm sorry, Mr. Elick, and regardless, what we do here is it's, I guess, peanuts, so to speak, because you're being held at no bond on 2 of your felony cases as is. So,
This is the moment bond stops being about money and starts being about risk. Judges aren't punishing here, they're predicting. The question becomes, will this person follow rules if released? And when the answer sounds like no, bond becomes irrelevant.
what I am going to have you do, though, is this. I'm going to have you sign with me today an affidavit promising me that you're not going to have any weapons. And if I find that you have a weapon, if somehow you are magically released, because I don't know what's going to happen, if I find that you have a weapon, I will have a contempt hearing. I can have a contempt hearing, and I can and may hold you up to contempt Every single time you have a weapon, and if they prove it to me, I can send you to 180 days in jail. Every single time. Do you understand?
Yes, sir.
This is an affidavit. This affidavit, you're going to promise me that you're not going to have any weapons. I don't care what's going on in your life. I don't care if you're going into war. I don't care if there's a big battle in the street. No weapons. Do you understand?
Yes, sir.
Look how big. Is that big enough for you to read? What does it say?
No weapons.
Good. We will have you swear to us that you're not going to have any weapons, and at that time, we'll just have you put back. If you do bond out, I'm going to put a GPS monitor on you, and I will put an exclusion zone so that you're not to go anywhere near the complaining witness in this case. Do you understand?
Yes, sir.
You know, did we ever explore that order to surrender weapons to the sheriff's office? Did we ever do anything with that?
I explored it and I talked to multiple people and no one's ever heard anything about it that I could find.
We had that, remember?
I know at one point we did.
We need to do something with that.
I'll make a few phone calls. See where.
I'm going to see what I can do about having the weapons surrendered to law enforcement so that you don't have possession of any weapons. Do you understand? Okay. All right, Mr. Lick. So I guess we'll just wait. It looks like the felony case is set for, oh my goodness, March of next year.
Your Honor, we may be, I just want to get the body cam and we may set this for trial. I mean, I know he's got the other
Wonderful.
felonies, but.
I'm itching for a trial.
Okay.
You want 30 days, I guess?
That sounds good.
Okay. All right. We'll have you swear to us no weapons, Mr. Jack. Come on.
Judge, I also have Shaquita Mitchell on your docket. We were reset today for the state to eval, which they have done. And I have a pretrial contract that was printed today. We just need some time to get community service done.
She has to do this community service.
Service in 2 classes, and I think she's already done 1 class. And
Great.
we're waiting on another one.
Is she here now?
She is here, Judge.
Ms. Mitchell, come up.
Hours of community service.
Hi, John D.
Thank you.
So one, I would assume, what are the classes?
Decision-making. Anger management, Judge.
And anger management, okay. Have you done any of the classes now?
I'm back in Beaumont since this case has occurred. My probation sent me back. So they're gonna have me doing thinking of a change and completing my community service and doing MHMR. So that's the only things I have to do in my probation.
This case, or are you on probation?
She's
I'm on probation.
She's on probation in Jefferson County, Judge, but in addition to that, this case, she's already done an anger management class that she's brought to my office last week.
Mhm.
But now the state's offering, in addition to that, effective decision-making in 20 hours for it to get dismissed. So I'm not sure if the community service she does while on probation can be used in conjunction with this, but I'm sure we can work something
I'm
out.
okay with that.
Okay.
I mean, have you done the community service yet?
Yes, I have done some of my community service.
Okay, then I guess make sure that Michael is okay.
Sure.
I am, but you got to understand if you're on, is it felony or misdemeanor
It's a
probation?
felony probation.
I mean, self-control. I would say 90% of the people that are in jail now are for one reason only, self-control. They react, they act without thinking and say, if I do this, what's going to happen? If I say this, what's going to happen? And then you end up back in jail, you pick up a new case now, and you're on felony probation. Jefferson County is a really tough county. They don't toy around like here in Harris County. You violate over there, they're going to they're going to lay you out. You understand that by pleading guilty to this case now, they can revoke that probation, resulting in further confinement.
But I'm not pleading guilty. I gave her all the evidence.
That's right. We're not doing a plea.
Correct, Judge.
Yeah.
We're not
So,
entering a guilty.
but at some point, you got to understand they're not going to continue to bend over backwards to help you.
That's why
Right?
because that was the problem.
You could say anything else.
Really.
Well, self-control. It takes two to tango, right? You get into a pissing match with other people, you get into a fight. Don't matter. Everyone's going down. Just think about that. Self-control. All right. So how long is it going to take you to get all this stuff done?
Right now, they got me looking for a job out there. I have an interview today. So hopefully after Thanksgiving, because everything's going to be shut down probably tomorrow. Or
Well, I don't want to, set you up to fail. I mean, your case is old, but we need to give you enough time that you can get it done.
Can we do the first or second week of January?
yeah.
That's a long time.
It is, but I know that with Christmas falling right behind Thanksgiving, if she gets it done before, then I can
My
always.
fear is that we get to Christmas, this, that, and nothing gets done. We're here in January, and then nothing's gotten done. I will give it to you, but I'm going to tell you now, if you don't have it done, I will carry you day for day until you have it done. will reset you Monday to Tuesday to Wednesday to Thursday to Friday, and then to next Monday until you have it done. Your case is 212 days now. We're giving you another 40 days now. You got to have it done. And if you don't, I'm telling you, I'm going to roll you day for day until you have it done. You understand?
And
It's not hard.
Right.
Everything can be done online.
She's pretty proactive. She's come to my office often and brought me evidence and proof of her classes. So she's doing everything she needs to. And
It's a
this is
sweetheart deal.
PTI.
It's a sweetheart deal. Work it. All right? Self-control. All right. Good luck, Miss Mitchell. All right. Thank you.
What happens when a judge decides the courtroom is no longer a place for second chances, but a line of defense for public safety? The day begins with Mr. Jack, a repeat felon, standing before the bench. The judge wastes no time. Case after case is read aloud. Multiple unlawful firearm possessions, a terroristic threat, and a chilling allegation involving threats to shoot an ex-partner during a custody dispute. When officers arrived, a gun was found. The judge immediately finds probable cause and makes his position crystal clear. This court means business. Jack is labeled a danger to public safety. His bond is questioned, strict no-contact orders are imposed, and a protective order is issued. The warning is blunt. One violation and he could be held on zero bond without hesitation. The judge goes further, forcing Jack to sign an affidavit promising no weapons, under any circumstance, backed by the threat of repeated contempt jail time if violated. If released, Jack will be tracked by GPS, boxed out by exclusion zones, and watched closely. Then the tone shifts. Next is Shaquita Mitchell, a woman trying to stay out of deeper trouble while already on felony probation. Instead of threats, the judge delivers a hard lesson: self-control. He explains how impulsive reactions land people back in jail and reminds her that probation violations can erase leniency instantly. Still, the court offers her a path forward: community service, classes, and time to complete everything. But the mercy comes with teeth. Miss the deadline, and the judge promises to reset her case day by day until it's done. Two defendants. Two very different approaches. One courtroom message: accountability comes first. Mercy only follows effort. Was the judge being too harsh to protect the public, or exactly as tough as justice demands?